Hi, my name is Robert Blackman. I'm a patent attorney with Merrick, Blackman & Voorhees. I've been involved in the patent field since 1988. Today we're going to talk about how to get a provisional application on file. You could file a non-provisional application, which is also called a utility application, but it does have a lot more sections that are required over a provisional application, and it's generally harder and subject to more scrutiny from the patent office when you file it, and it has a higher fee. You'll have to file a utility application eventually if you want to get a patent, because only the utility applications are reviewed by the patent examiner and passed on to allowance and issue. But the provisional application will get you on file and will get you your patent pending and your filing date. As we go towards the America Invents Act and its implementation next March of 2013, we're going to go from a first to invent system to a first to file system, so it can become very important on what your actual filing date is. And if you can write a provisional application that includes all the subject matter necessary to adequately describe your invention, it could be a big benefit. Provisional application, as I said, only lasts for about a year before you need to convert it or file a non-provisional application to follow up with this. But you can think about a provisional application as being a draft. It has two main sections, the written section and the drawing section. In some cases you could get away without the drawing section, but I don't recommend it, because that is one of the things that the patent office will review, and you may end up having to argue that your patent you have adequately described your invention without the drawings. But if you go ahead and put the drawings in, then you won't have to pass that hurdle. The written description should be as thorough as you can make it. It's important to have what they call the best mode, the best possible way that you know of making, using, or implementing your invention. What you want to do is write as to a person that's one of ordinary skill in the art. In other words, if it's in the car field and you're inventing a new engine, you don't really have to explain to them how the engine gets mounted to the body and how to run the gas lines and things like that, that one of ordinary skill would already know. You want to concentrate on what your invention is, and how the improvements are and what they're for. You should also try and provide any alternatives that you can. For example, if your invention were a pencil, adding a new eraser to it, in addition to being on a pencil, it could be on a pen, it could be on a mechanical pencil, etc. You want to think about these different options. They will help the patent attorney who eventually writes your claims write them as broadly as possible to protect you as best he can. When you're going through the drawings, each drawing should have its own label, figure 1, figure 2, figure 3, etc. And each item that you're going to describe in the invention should have its own individual label as well. In the pencil example, the wooden shaft could be 10, the graphite tip where it's the pointy section could be 12, and the eraser could be 14, and the band 16. It's most convenient if when you're writing the application you describe the parts in numerical order. For example, if you said, I'm describing a pencil 10 that has an internal graphite shaft 12 with an eraser 14 connected by a metal band 16, then somebody could look at the drawing and say, what is element 16? And they just look through your application and count the numbers until they get up to 16. If you wrote them out of order, it would be much harder for them to go through and find the different elements where they're described in the specification. Although it's not a requirement, it's good practice. I also recommend that you skip numbers like I was talking about, 2, 4, 6, 8, and starting with 10, in case you need to come back later and add an element. It gives you a couple extra numbers that you can put in there and still kind of remain close to order. But those are the main sections that you need to get on file. The provisional application is kind of replacing what used to be the document disclosure program, so they've made it a little bit easier for you to file. Again, I recommend that you use a patent attorney, but if you can't, this is the best way that I know. Once you've completed the drawing and the specification, the written portion, you're going to need to file them at the patent office. You can file them, you'll need a provisional application cover sheet. The form is available on the patent office website, and file it either electronically at the electronic filing system or at their walk-up window. You can find the links to the America Invents Act, the EFS system, and the forums on our IP links and PTO index page. Thank you.